Good evening. I'm Sarah Watson, and I'm the Executive Director of Looking for Lincoln and the Abraham Lincoln National Heritage Area. Welcome to tonight's Looking for Lincoln Conversations. Our topic tonight is the Presumption of Freedom, the Illinois Supreme Court, and the fate of slavery in the Prairie State. Though Illinois entered the Union as a free state in 1818, slavery continued to exist within its borders for decades. Freedom seekers, abolitionists, and pro-slavery forces turned to the judicial system to determine the fate of slavery in Illinois. This talk will highlight several of the nearly 24 slave cases that reached the Illinois Supreme Court and examine the court's role in ending slavery in the Prairie State. We're joined tonight by John Lupton, Executive Director of the Illinois Supreme Court Historic Preservation Commission, and Samuel Wheeler, who's the Director of History Programs for the Illinois Supreme Court Historic Preservation Commission. Nice long name there, guys. Thanks. There is no one better than these two gentlemen to talk about historic Supreme Court cases. So it's my pleasure now to introduce John and Sam.
Thanks for having us back, Sarah. So this is a talk that John and I developed in support of Looking for Lincoln's wonderful traveling exhibit on the Underground Railroad. We wanted to help complicate the story that they tell in that fascinating exhibit that's appearing all around spaces in the state of Illinois. When you go through that exhibit, you'll see stories of individuals that are fleeing slavery. Oftentimes, they're fleeing slavery in southern states. They're traveling through Illinois on their way to freedom, utilizing the Underground Railroad as a pathway to freedom. The story that we're going to share with you tonight maybe complicates that story in the sense that many of these folks that are unfree in the stories that we're going to tell you tonight weren't fleeing from states in the Cotton South. They found themselves in unfree conditions in the state of Illinois. It is a complicated story and one that we've been thrilled to do a lot of research on to share it. And so let's get started. Antebellum America is often divided into free states and slave states. And Illinois complicates those terms in many respects. When it entered the Union in 1818, Illinois didn't fit neatly into either one of those categories. Illinois truly was a quasi-slave state. And here's how that process of slavery sort of played out in the state of Illinois. We inherited slavery in many respects. When French explorers came to the Illinois country in 1673, they were the first Europeans to set foot in the Illinois country. By 1720, they introduced slavery into the Illinois country. They imported African slaves into Illinois. Originally, they were used in mining enterprises and then eventually into agricultural pursuits. These slaves and their descendants are the infamous French slaves in Illinois history. They will remain unfree laborers in Illinois for the next 125 years. In 1763, when the British took control of the Illinois country after the French and Indian War, they allowed those French inhabitants to keep their slaves. When, after the American Revolution, the Americans gained control of the Illinois country, the Confederation Congress passed a remarkable document known as the Northwest Ordinance in 1787 that really organized territory that included Illinois. Article 6 of that document outlawed slavery in the entire Northwest Territory. The idea was that that territory would evolve with all the advantages of Republican government, yet they wouldn't be burdened with the institution of slavery. That's a good idea. It's one thing to make law. It's another thing to interpret law. When the settlers of the Northwest Territory interpreted that prohibition on slavery, they interpreted it to mean no new slavery in the Illinois country. If you already had slaves in this region, They interpreted on the ground to mean you could keep them in this territory. You just couldn't bring new slaves into this area after 1787. Thus, the French inhabitants in Illinois could maintain their unfree laborers. So chattel slavery was grandfathered in to the Illinois country. And then other loopholes emerged into the Northwest Ordinance. New settlers from southern states who wanted to bring their slaves with them into the Northwest Territory couldn't bring them as regular chattel slaves. They couldn't bring them as involuntary laborers. But that ordinance said nothing about bringing in voluntary laborers. And so a new system emerged where these masters would draw up indenture contracts with their property. These indenture contracts would be entered into voluntarily in theory. So in return for room and board, servants pledged their service for a number of years to their masters. Sometimes these indenture contracts would last for 7 years, sometimes 15 years, 30 years. There are even a few examples in Illinois of 99-year indenture contracts. That's slavery by another name. The Indiana Territory passed such laws. The Illinois Territory adopted those laws. So just before statehood, a system of pseudo-slavery was alive and well in the Illinois Territory. What happens once Illinois becomes a state? Take it away, John.
So in 1818, Illinois becomes the 21st state to enter the Union. And as was the custom at the time, there would be a free state that comes in with a slave state to keep the balance in the U.S. Senate the same. So neither free states nor slave states would have a majority in the Senate. So Illinois comes in as a free state, but on the surface, the Constitution of 1818 outlawed slavery. In the Constitution, it says neither slavery nor involuntary servitude shall hereafter be introduced in this state. The key word here is hereafter and introduced. So the translation of those two key words there is that it meant, as Sam said with the Northwest Ordinance, no new slaves. So you couldn't bring in new slaves to the state of Illinois, but it did allow the French to keep their slaves that they had had since the 1720s. So the descendants of those first African slaves in the French African slaves in Illinois remained in servitude. And also the voluntary servitude contracts that Sam just talked about, those were also formed prior to statehood. So those remained intact as well. So the servants were required to serve out the entirety of those terms that they agreed to prior to statehood. So when Illinois enters the Union in 1818 as a free state, about 1,000 of its 35,000 inhabitants were legally held as slaves. So does this mean, was Illinois really a free state? Well, not exactly, but Illinois also wasn't a full-blown slave state either. So Sam, do you want to talk about that a little bit?
Yeah, so Illinois is not a completely free state in 1818 with 1,000 of its 35,000 inhabitants having a restriction upon their freedom. But Illinois isn't quite the full-blown slave state that Mississippi or South Carolina would be at the same time either. It's strange. Illinois exists sort of in this middle ground. The Illinois Constitution of 1818, in some respects, introduced a concept of gradual emancipation into the state. The Constitution envisioned a day in the future when slavery would no longer exist in the state. So if we look at those involuntary or those voluntary contracts, some of those long-term indenture contracts, there was a system that the children of those indentured servants would be enslaved as well, would be indentures to the master, but their children would not be. And so over the course of time, who knows exactly how long that time would be, the Constitution does envision a day where Illinois would rid itself of slavery in a way that Mississippi and South Carolina certainly didn't envision that day in their state constitutions. That's an important point, I think, for us to keep in mind. So antebellum Illinois is located somewhere north of full-blown slavery, but also south of real freedom. And what are laws that are put in place to maintain this middle ground?
So, even though Illinois was a free state, it doesn't mean racism didn't exist either. So what the first Illinois legislature did is they passed a series of black codes to sort of regulate how African Americans were to be treated in the state of Illinois. And these were regularly strengthened throughout the antebellum period. So we'll kind of touch on the black codes as we continue talking here. But yeah, basically the black codes were meant to restrict the freedom and to deny civil and political rights of Illinois African Americans. So just, as a couple of examples, so African Americans were required to carry with them a certificate of freedom to prove that they were not a slave. They had to register with the county clerk in whatever county they were going to live in and post a $1,000 bond to ensure that they would not become indigent. So if you were black in Illinois and you didn't comply with these requirements, you were considered to be a fugitive slave. And then the black codes had a structure, a procedure in place to deal with that. But the key point here is that if you were black in Illinois, the responsibility was on you to prove that you were not a slave. And so we'll touch on that in one of the cases here coming up. So
in addition to those black codes, Illinois has its own version of a fugitive slave law passed in 1819. Even though the United States Constitution has a fugitive slave law, Illinois passes its own version, in some ways a harsher version of a fugitive slave law, meaning if a black person is found in Illinois that doesn't have a certificate of freedom, that is not registered with a county, that hasn't posted their bond, by definition, according to Illinois law during this time period, they are a runaway slave. And a system is in place to return that fugitive slave, that runaway slave, to their rightful owner. And so what does that system look like? I'll spare you the details, but in essence, the person would be arrested. They would be brought into court. They would be put on the record that they do not have a certificate of freedom. They haven't followed the rules to register with a county, etc. And so a system would be in place where an ad would be placed in the newspaper. It would describe the person, and it would try to find the owner of that person from a slave state. If no rightful owner is found, that person's labor would be auctioned off on the steps of the county courthouse for a period of 30 days. An Illinois citizen would put that person to work for 30 days. An auction happened every 30 days for 1 year until the rightful owner came forward. If no owner came forward after that year-long process, the African American would be given conditional freedom papers, and they would be asked, if you're going to stay in Illinois, you're going to have to post that $1,000 bond and register with your county. Chances are they're not going to be able to do that. And so they were basically told in no uncertain terms, you better move out of state because Illinois is not a safe place for you to be. That's what life is like for African Americans in the free state of Illinois during the antebellum period. So if we think about that exhibit, the freedom seekers utilizing the Underground Railroad in Illinois, they weren't always coming from a slave state into the state of Illinois on their way to freedom. Some of those individuals that you'll hear about in those cases that get caught up in the legal process in Illinois, they found themselves in unfree conditions in Illinois. They didn't originate in a slave state. And we're going to share with you a number of those stories tonight through the medium of Supreme Court records. So I'll share one with you right now. A case called Cornelius versus Cone in 1825. We said that the Constitution of 1818 honored the indenture contracts that were written prior to statehood. But the Illinois Supreme Court insisted that those contracts were written in strict compliance with the law. And when I started to notice this pattern while going through early Illinois Supreme Court cases, it was revealing to me. It was revealing in the sense that a pattern emerged where Illinois Supreme Court justices, this is my word, were eager to find problems in those indenture contracts. And they oftentimes ruled in the favor of freedom for those individuals that had a restriction upon their freedom. And this is the case in this one. Here's the, in many ways, horrific details of this case. In 1804, a 23-year-old girl named Rachel bound herself with an indenture contract to a fellow named Joseph Cornelius. The contract was written for a period of 15 years. In 1805, Rachel, the indenture, had a little girl named Betsy. According to territorial law, Illinois hadn't become a state yet. Betsy, the little girl, owed her services to the master Cornelius until she turned the age of 28. According to the law, all Cornelius had to do was register Betsy's birth with the county within 6 months of her birth, and he was entitled to her labor for the next 28 years. After statehood in 1819, Rachel's, the mother's, voluntary servitude contract expired. She was free to go, but not her young daughter. Through the help of some abolitionists, they were able to file a lawsuit. And it's interesting, the judicial system at this point becomes another pathway to freedom, possibly. In 1821, a 15-year-old Betsy sued her master, Cornelius, for assault and battery and false imprisonment. In other words, she filed a freedom suit. She was challenging the legality of her unfree condition. The case went all the way to the Illinois Supreme Court. So at the circuit level, they ruled Betsy still remains the legal property of Cornelius. The case gets appealed all the way to the Supreme Court. What does the Illinois Supreme Court decide? The Illinois Supreme Court closely analyzed the original 1804 indenture that Rachel signed, that the mother signed back in 1804. They realized there was a slight mistake in the paperwork. The county clerk did not sign the right spot on the form that articulated the number of years that Cornelius would have the right to Rachel's labor. The court rules, because the document was faulty, that the original indenture was null and void, and Betsy could go free. The legal system proved to be a pathway to freedom. And the justices, we see this pattern, they're eager to find those mistakes. John's going to tell us about another really significant case.
Yeah, before we get into that, I just kind of want to point out, so that was an example of, where the court was, found a fault, but it wasn't exactly a linear path, because sometimes it was 2 steps forward, 1 step back. But probably one of the biggest leaps forward was the 1841 case of Kinney versus Cook. So just the quick background of this is that Thomas Cook was a slave who was owned by William Kinney in St. Clair County. And Cook ends up suing for his freedom. He hires Lyman Trumbull to be his attorney. Lyman Trumbull was a anti-slavery Democrat, later Republican, who ends up being elected to the U.S. Senate, so forth and so on. We'll talk more about Trumbull in a little bit, but very much anti-slavery, and he was kind of an activist lawyer. So Trumbull, represents Cook, sues Kinney, and Kinney, Cook is basically saying that I provided services to Kinney, but I was never paid for my work. Kinney's response, of course, is, well, I didn't pay him because he's my slave. So the case eventually makes its way to the Illinois Supreme Court. And so the court asks Kinney to provide proof that Cook actually owed him his labor, but Kinney didn't have that proof. So the court rules in favor of Cook. But the court kind of takes it a step further in saying that, that it was the responsibility of the master to prove that the person owes them this labor. So the burden of proof is now on the master. Remember, I had talked earlier about how if you were a black person in Illinois, you were considered to be a slave unless you proved yourself free. Well, now the Supreme Court is basically flipping that script. And in a sense, it's challenging what the Illinois legislature has said with these black codes. So they created this precedent, the presumption of freedom. So basically, it's the idea that an African American in Illinois is presumed to be free and not a slave. So again, this is a direct rebuke to one of these black code requirements. And at the very same term, there was another case that was going on called Bailey v. Cromwell. And the court used the same presumption of freedom to prove that Nance, an alleged indentured servant, was actually free because there was no contract in place. Abraham Lincoln happened to represent Nance's interests in that case on the side of freedom. And in his brief, he used the Northwest Ordinance and several cases that established this principle. But the presumption of freedom, that is the key word here in both the Kinney case and the Bailey case. But as I said, this isn't a straight path towards freedom. So, Sam, do you want to talk about one of the cases where we had a step back?
Yeah, a step back certainly occurred in the case of Sarah versus Andrew Borders in 1843. A little background to the case. In 1815, a 21-year-old woman named Sarah was brought from Kentucky to Illinois. She signed an indenture contract to serve William Patton for 40 years. Her contract was sold several times before she finally became indentured to a fellow named Andrew Borders in 1825. In the 1840s, Sarah ran away from Borders. She became a freedom seeker in Illinois. She sought shelter with a number of individuals. Eventually, abolitionists in the state of Illinois befriend her, and in 1843, Lyman Trumbull again appears in the Illinois Supreme Court records. Working with Gustav Kerner, they file a freedom suit on her behalf. The case makes its way all the way to the Illinois Supreme Court. At the Illinois Supreme Court, Trumbull used the classic abolitionist argument, one that was familiar to lawyers at the time. He said that the territorial laws that sanctioned slavery, the Constitution of 1818 in Illinois, and all the subsequent state laws that protected slavery were in direct violation of the original Northwest Ordinance of 1787. He quibbles with the way that Northwest Ordinance of 1787 was interpreted on the ground, because in his mind, in the abolitionist mind, it was supposed to outlaw slavery. But yet, as we said earlier, it didn't, with these loopholes. The Illinois Supreme Court rules against Trumbull, rules against his argument. He had used that argument many times before. He will continue to use that similar abolitionist argument in the future. But the Supreme Court in this case says limited slavery as it's protected in the Constitution of 1818 and in state laws is constitutional. So Sarah remains indentured to Borders. Now, what's interesting about the case is that there's additional litigation that goes on. Matthew Chambers was a white shoemaker in Randolph County. When Sarah originally ran away from borders in the 1840s, we said that she sought the help of individuals. Chambers is one of these individuals that extended a hand to Sarah while she was seeking freedom. Chambers was charged with harboring a fugitive slave in Illinois for this act. According to Illinois law, he was fined up to $500, including 1 year in jail. At the circuit level, Chambers was found guilty. Chambers' argument is interesting. He said he didn't know that she was a runaway. He didn't know that she was fleeing an indenture contract. He simply answered the door when somebody knocked at his door and asked him for a warm meal and a place to stay. The court, the prosecutors, said that didn't matter. She was a Black person in Illinois, thus she's presumed to be a slave. So Trumbull defended Chambers in his appeal to the Illinois Supreme Court. And remember that case and that precedent that John talked about just a few minutes ago. Trumbull appealed the case, and he gets the Supreme Court this time to agree with him. The lower court ruling was wrong, the Supreme Court says. There was no evidence that Chambers knew that Sarah, when she knocked on his door, was a runaway, a fugitive slave. The court says that Kinney versus Cook, that 1841 decision, declared that in Illinois, there's a presumption of freedom. Just because she was a Black person, there was no requirement on his part to assume that she was unfree. Justice Samuel Lockwood's opinion in this case states that Chambers was simply offering hospitality to somebody that was in need, and he had a right to do so. Lockwood wrote in his opinion that if we assumed that all Blacks in Illinois were enslaved, that would make it dangerous for the people of this state to extend the most common offices of humanity to that unfortunate class of mankind to who God has given a skin colored differently from ours. It would be illegal to receive such persons into our homes, although they were perishing in the streets with hunger, cold, and sickness. So in other words, the court very strongly is affirming that presumption of freedom principle in Illinois. Illinois, it's a complicated place, but the court is saying we are definitely not like those other slave states of Mississippi or Georgia or Alabama in this case.
So we've kind of been talking about freedom seekers who are indentured servants to Illinois. So again, slavery in another name. But the next case that I want to talk about kind of deals with a freedom seeker who actually was a slave from Louisiana. And that's the case of Willard versus the People that goes to the Supreme Court in 1843. So basically what's happening in this case is this woman from Louisiana visits her sister in Jacksonville, Illinois for several months. And this woman, Sarah Lyle, she brought her teenage slave, Julia, with her. So while in Jacksonville, which is a hotbed for anti-slavery, Julia actually meets up with some abolitionists, and so they help her escape. But she was captured, and one of the people who helped her escape was a man by the name of Julius Willard, and he was arrested for harboring a fugitive slave. And during the trial, they were found guilty, kind of received a slap on the wrist, but Willard appealed the case to the Illinois Supreme Court. Willard's lawyer is arguing Illinois is a free state, so there are exceptions, the French slaves, the voluntary servants. But in this particular case, since Sarah Lyle brought her slave with her from Louisiana to Illinois, just by virtue of stepping foot into the state, she becomes free. And this is known as the freedom principle. This and other states had kind of passed similar laws to establish this freedom principle that if you are a slave and you immediately step foot in a northern state, you are free. So Massachusetts, Connecticut, they were all doing this. But the Illinois Supreme Court says no. And again, this is kind of another one of these steps back, I would say. The Illinois Supreme Court rules against Willard. allowing the Menard County judgment to stand. And the court basically says that Illinois allows slave owners the right of transit. So the issue of comity, comity, that they can, slave owners can pass through Illinois with their property, whether that's their, horses or slaves, whatever it is, they can take their human property with them. So a slave in Illinois does not become free the moment they set foot on Illinois soil. So Illinois was really one of the last states to maintain this right of transit for slave owners. And it kind of makes sense. Actually, in one sense, it's consistent to show that Illinois still occupied this middle ground between freedom and slavery. And again, if you look at the geography of it, we are wedged between two slave states. Massachusetts is not. Connecticut is not. So, and I'm certainly not defending what Illinois was doing or what the Supreme Court was doing in the Willard case, but you can see that it makes sense that they were basically being consistent with a lot of their rulings over the past several years of maintaining this middle ground between freedom and slavery. So, Sam, you want to talk about the big case?
Yeah. So, I just think it's interesting. The last two cases that we talked about, we established firmly this presumption of freedom, principle where we define ourselves. We are not like those other slave states. And yet, in this case, by not adopting the freedom principle, like our friends in Massachusetts and Connecticut did, we're firmly saying we're not like those other abolitionist states in the Union either. Again, we're somewhere different. And so the big case comes about in 1845. It's known as Giroux versus Giroux. This is a landmark case in the history of Illinois, not just the Supreme Court history, but it's so significant because it officially ends chattel slavery in Illinois. A long story short, the descendant of one of these original French slaves in Illinois sues for his freedom. And who defends this person, who argues the case on appeal before the Illinois Supreme Court? But again, Lyman Trumbull, a name that I think this is the third or fourth time already in this talk that we've talked about Lyman Trumbull, a person today that we would define as an abolitionist, but he would probably quibble with us if he were around listening to us talk about him. He was somebody that probably recognized the legality of slavery in the slave states, yet sees a state like Illinois and believes that slavery in all of its forms are unjust. So he would say, perhaps he's not an abolitionist in the true sense of the word, but in my opinion, he's one of the most effective abolitionists in Illinois history, if we think about his role in ending chattel slavery in Illinois. His argument before the Illinois Supreme Court in this case is the classic abolitionist argument he had made many times and many of his colleagues had made, where he talks about those French slaves and their descendants should not be unfree in the state of Illinois due to Article 6 of the Northwest Ordinance from 1787. It had been misinterpreted originally, and that was the original sin of the territory of Illinois, and some court should step forward and right that wrong. Trumbull had made that argument, as we say, many times before. He wraps up his argument by declaring, quote, "If words are not mere empty sounds, if they mean anything, then the plaintiff is free by virtue of the express declaration of the Northwest Ordinance." And on this day, the Illinois Supreme Court ruled in his favor, 6-3. The Northwest Ordinance had freed, indeed, all the slaves within the territory in 1787. So it ends chattel slavery, French slaves in Illinois, but it doesn't touch specifically those long-term indenture contracts. So though we have a major victory in 1845, there's still more work to be done. Lyman Trumbull, he's an activist lawyer. He is anti-slavery abolitionist in terms of how he sees slavery in Illinois, There were other colleagues in the legal system in Illinois who saw their role as a lawyer in similar terms. They fought tooth and nail to end slavery in Illinois. They did not become rich off of that. They did it because morally they believed that was the right position. We have the most famous lawyer in Illinois history is Abraham Lincoln. He goes down as the great emancipator for good reason in American history. But John is going to tell us about a case, and maybe there's nobody better, in my opinion, than John to tell us a little bit about how Abraham Lincoln, as a lawyer, combated slavery during the antebellum period. And it might be surprising to some of you.
Yeah, right. So, Sam talked about how Lyman Trumbull was an activist lawyer. Was Abraham Lincoln an activist lawyer? No, he was not. We do, have him working on behalf of freedom in that Bailey v. Cromwell case in 1841. But just 6 years later, he was involved in the Matson slave case. This shows that Lincoln isn't an activist lawyer, but he's basically, your typical attorney. He's happy to argue both sides of a case. And, I do want to just make the point, too, that, just because Lincoln represents a slave owner in a case doesn't mean that he's pro-slavery, as, some historians might argue. It would be saying the same thing that just because you defend a rapist in court, you support rape. Well, of course not. So Lincoln is basically just acting as an attorney. That's what he does. He's a hired gun. And this case might be the best example of it. So just a quick background, and I know probably a lot of you Lincoln people know about this case. Robert Matson bringing his slaves with him to Illinois. Robert Matson was a Kentucky slave owner, brought slaves to Illinois to work on his farm during the planting and harvesting seasons. In 1845, he brings Jane Bryant and her children to work on the farm and keeps them there for 2 years. And then after 2 years, Jane Bryant befriends some abolitionists. They help her escape, and Matson has the abolitionists arrested, and Jane and her children are brought to court. Matson then hires Abraham Lincoln to help get his slaves back into bondage. So at the trial, the abolitionists and Lincoln's side are arguing that, the abolitionists are arguing that Matson broke the Illinois law by bringing his slaves into Illinois because he's bringing slaves to Illinois. There is no slavery in Illinois. So, but Lincoln, in response, he cites, he talks about the Willard decision. He talks about the right of transit, comity, C-O-M-I-T-Y, and that slave owners could bring their property with them into Illinois to pass through or even to visit for a time, and then they could leave with them. This was not a Supreme Court case. I should point that out. This was only a circuit level case, but it was heard by 2 Illinois Supreme Court justices because at that time in Illinois history, Supreme Court justices rode circuit. So in addition to their appellate duties on the Supreme Court, they would hear trial level cases at the circuit court. Well, it so happened that the Justice Samuel Treat, William Wilson, whose circuit was Coles County was in, which is where this case occurred, Samuel Treat was passing through. So he asked Treat to sit in with him on the case. So you had 2 Supreme Court justices hearing this case. The 2 Supreme Court justices even write an opinion in the case, which is very, very, very rare for a circuit level case. And they rule against Lincoln's argument. So, and that the Willard decision really didn't apply in this case, because Matson's intention was not to visit or even to pass through. He was bringing slave labor from Kentucky to work on his farm and then take them back to keep them as slaves. That's not visiting. That's not passing through. So the court freed Jane Bryant and her 4 children. In Lincoln historiography, this case is known as the Matson slave case. I think that removes Jane Bryant's agency from this case. So I like to refer to it as the Bryant freedom case instead of the Matson slave case. I think that's a much better description of what was going on in that she's suing in an action of habeas corpus to obtain her freedom, and she's successful in doing so. So, Lincoln was on the wrong side of history in this case, clearly. He did not like slavery. He was anti-slavery, but he was not an abolitionist, and he was not an activist lawyer. So he very easily could have argued the abolitionist side. And in fact, he was approached by the abolitionist side, but he had already pledged his services to Matson's side. If the abolitionist side had come to him first, I'm certain he would have appeared on that side as well. So Lincoln is kind of on both sides of this argument. Again, with Bailey v. Cromwell, he's arguing for freedom. In the Matson case, he's arguing the issue of comity, that masters from the South can bring their slaves through Illinois. So this is kind of a big case. So we kind of got these three big cases that Sam and I both talked about. So Kinney v. Cook in 1841, Giroux in 1845, and Matson in 1847 that kind of end different forms of slavery in Illinois. So we've got one more big step left. Sam, what is that?
Yeah, so we've told you a story that takes place over 30 years of Illinois history. And I think subtly, you can see the trajectory of where the court sort of sees the future of Illinois. They see the future of Illinois not being bound together with slavery, but they see the future of Illinois being in the realm of freedom. In 1845, the Supreme Court ended chattel slavery with Giroux versus Giroux. The only form of slavery that existed after that case were those problematic voluntary servitude contracts. There's a new constitution, constitutional convention. The new constitution of 1848 takes place, and this is the moment that they forever outlaw those voluntary servitude contracts in our second constitution, the Constitution of 1848. By the way, a really problematic constitution in terms of race, in terms of civil rights. The thing they do that's good is they outlaw these long-term servitude contracts. Wow. So in 30 years, the story that we've told you, slavery in all of its forms ends in the state of Illinois by 1848. How did it end? There was no bloody civil war that took place in Illinois to end slavery in all of its forms. Slavery died gradually, and it died peacefully, and the courts helped play an important role in that process. Every census after statehood, after 1818, the number of slaves in the state decreased, and the end of Illinois slavery was hurried along by a lot of different factors. We focused a lot tonight on the important role that activist lawyers and the judicial branch played in that. But there's also other things that need credit, like a demographic shift in our population in Illinois. In 1818, the earliest days of statehood, the population of Illinois was made up of Southerners, folks that migrated up from the upland South that had oftentimes personal relationships with slavery. After the Erie Canal into the 1830s and 40s, Illinois begins to be populated by Northerners, folks from New England, abolitionism, a background in abolitionism, for instance, folks that weren't so necessarily sympathetic to slavery. And so a combination of things gets us to the point in 1848 where we no longer have slavery. Illinois politicians go on to play a role in the national conversation throughout the 1850s. The most prominent example of that is the Lincoln-Douglas debates of 1858. The subject of that Senate race in Illinois is the expansion of slavery across the United States. Specifically, if we look at the Lincoln-Douglas debates, they're debating this topic. Does Congress have the right, the ability to ban slavery in the Western territories? That culminates with the Kansas-Nebraska Act drama. that's an interesting debate because two Illinoisans, Lincoln and Douglas, are debating this. At its heart, think about who they are and what their relationship with that very question. Isn't that the question that abolitionist lawyers are arguing during this 30-year stretch? The Northwest Ordinance had asserted the right of Congress to ban slavery in a territory, right? And so on this national conversation that takes place in the 1850s, it's interesting that two Illinoisans are arguing opposite sides of this coin. Of course, Lincoln makes a national name for himself in those debates. Stephen A. Douglas wins. He retains his seat in the United States Senate, but they would square off 2 years later. And that election, not only is the most contentious election in American history, but it sparks the Civil War.
Yeah, Lincoln's elected president in 1860, as we all know, and Republicans ran on the idea of blocking the expansion of slavery. They wanted to prevent the expansion of slavery because they didn't believe that they could end slavery under the U.S. Constitution, but they thought that it would be able to die out peacefully and gradually over a period of time. Sound familiar? It's exactly what Illinois did over its 30 years. It died out peacefully and gradually. That did not work, obviously. But, let me get back to Lincoln here for a second, because Lincoln is in this environment in Illinois where he knows what's going on with all of these cases. He sees that slavery in Illinois is being eliminated. And he thinks he can replicate that same model at the federal level. It obviously doesn't work. Southern states secede because they fear he is an abolitionist president, which he never claimed to be, and he never was. He didn't really become an abolitionist until well into the war. So, I think the Southern states clearly overreacted to Lincoln's election, but the dream was to end, slavery, put it on its path to ultimate extinction. So, as we know, he does not move quickly against slavery. And it's not until, a major battle where he finally issues his Emancipation Proclamation. But another sort of tidbit about Lyman Trumbull is, Lyman Trumbull, as a U.S. Senator, authored the Confiscation Acts, which allowed the Union armies to confiscate Southern property, including slaves. So that Confiscation Act eventually leads to the Emancipation Proclamation, which obviously in that Lincoln declares that the slaves of those in the Southern states in rebellion against the United States are free. And it's based on his power as commander-in-chief. It's a war measure. He knows that it's not binding and that he needs something else in order to eliminate slavery permanently under the U.S. Constitution. And that he's able to do with the 13th Amendment.
So the United States Congress, the United States Senate, in the form of Lyman Trumbull, pushes Lincoln in many respects to issue the Emancipation Proclamation. Who knows necessarily what the legality of the Emancipation Proclamation will be? How long will it last? It's issued as a war measure. Will it expire at the end of the war? What will be the fate of slavery? Something more binding is going to need to happen. And that's how we get the 13th Amendment to the United States Constitution. The United States Senator Lyman Trumbull, the same attorney from Illinois, now is in the Senate. He authors the 13th Amendment to the United States Constitution that outlaws slavery everywhere in the United States. It's passed in January 1865. It's not ratified yet, but Lincoln, by the time he goes to Ford's Theater, he knows that it's a matter of time before this before this amendment will be ratified and slavery will be gone forever in the United States. Illinois becomes the first state in the Union to ratify the 13th Amendment. And then, of course, by the end of the year, December of 65, it's ratified and becomes law. The same year, 1865, the war's over. Illinois finally removes its black laws, those laws that denied black people civil rights in many respects in the state. And that's this story that we've shared with you tonight, it's an epic turnaround for the state of Illinois. Illinois entered the Union somewhere between a free and a slave state. We weren't Massachusetts, but we weren't South Carolina either. But Illinois gradually and peacefully rid itself of slavery within its borders. And then Illinois and Illinoisans went on to play a major role in ending slavery in the United States. More than 250,000 Illinoisans fought for the Union Army. Lyman Trumbull pushed the president from the Senate, and Lincoln embraced emancipation. He embraced the end of slavery, and by the end of his life, the last speech he ever gave, April 11th, 1865, from a window in the White House, he became the first president in American history to endorse voting rights for some African Americans. Quite the story, with a wonderful judicial connection that I hope complements the exhibit. And it's been a pleasure sort of uncovering that story, and it's been good talking to you tonight, John. And
yeah, good talking with you, Sam. And
audience.
Yeah. Heather, do we have any questions from the audience? We've got a few minutes to maybe deal with some questions.
Yeah, we do. We do have some questions.
Great.
Hello, everyone. My name is Heather Fieser, Program Manager for Looking for Lincoln, and it is time to take your questions. So if you have not done so yet, please type them in the comment section, and we will try to get through the questions. But the first one, I believe you guys referenced the Betsy Cornelius case of 1825. And the question was this case covered in the newspapers? Like, would this have been something that was covered in the newspapers?
Which case? I'm sorry.
Cornelius case, 1825.
The Cornelius case.
Oh, okay.
The research I did on that case came from court records. I did not go to the newspapers. It's as a general rule, these cases sometimes do get talked about in the local newspapers. 1825, sometimes some spotty coverage. But as a general rule, yeah, sometimes these would be in the newspapers. This particular one, I can't help you. I'm not sure.
Yeah, I don't know the answer to that one either. I mean, newspapers are kind of scarce in the 1820s, so I don't know how extensively it was covered.
And where was the case heard? Would that have been heard down in Vandalia in 1820?
Yes, that's correct. Right. It would have been at the Supreme Court in Vandalia.
Yeah. I thought based on the dates, I was assuming that would be where it would have been. Okay. So I have a question, and you've talked about him a lot tonight, which is about Lyman Trumbull. So you really paint him as this activist attorney who's taking cases. I think today we'd call it like more pro bono to try to like move an agenda forward. Is that kind of how you see Lyman Trumbull? Is like he's kind of taking up this banner of freedom and like using the legal system to kind of change law in Illinois? Is that to me is what you're painting a picture of Lyman Trumbull doing?
That's the picture that emerges of who I see Lyman Trumbull as. He's an attorney. He's working within the judicial branch, even becomes a Supreme Court justice in Illinois for a brief period. But he's a politician. He's a complicated politician too, by the way. At one point in his life, he'd been a member of like every political party that you could possibly imagine, which doesn't do great for his historical legacy, right? He's ticked off a lot of people. And it's interesting, you know, in my mind, Lyman Trumbull is one of these giants in Illinois history, but very few people know his name today. Historians haven't gone out of their way to tell his story. In part, I think because it's complicated. He jumps around political party to political party, but I definitely see his judicial activism, his role as an attorney, trying to transform Illinois society. And as a politician, he's trying to do that as well. And he does it successfully, very successfully at the state level. But like many Illinoisans, his activism translates very well to the national level. he played a incredible role during the American Civil War and Reconstruction too, by the way.
Okay, so here's another question from our audience, and it's kind of taking what you've talked about and expanding on it. So you may not be able to answer it, but I'm going to try because you may be able to answer this. So the question is that Indiana and Illinois and Ohio struggled with slavery issues from, the Northwest territories. So the follow-up question is, and this is a leap because this is not an Illinois question. Did Michigan Territory have a better record as a free territory or state, or did they too have the same struggles?
Yeah, that's go ahead, Sam.
I was just going to say it's a really good question, and it is something that we try to do today in terms of plugging Illinois history into a larger narrative of Midwestern history, of the history of the Old Northwest. In terms of Illinois' struggle, we have a lot in common with Indiana. Ohio sort of originates a lot of this. Illinois is carved out of the Indiana Territory. Many of the territorial laws that Illinois adopted were just a copy and paste job from Indiana territorial laws. Michigan has a better history in terms of this issue of slavery than Illinois. It's slower to develop. It develops along different lines, has more in common with, say, Wisconsin, perhaps, than Illinois in this regard. So a much better record in many ways.
And that makes sense too, because, as Sam was pointing out, and this is what I was going to say, Ohio, Indiana, Illinois, they all border slave states. Michigan, Wisconsin, they do not. And I think that landlocking of a free state makes it different in a little bit in several regards. Because the people who are moving to Michigan, they aren't generally from the upland South where slavery was legal. They're from the Northwest, or they're immigrants coming in from Europe who are opposed to slavery anyway. So you kind of get what you have in Northern Illinois, where you have a lot of Northeastern and European immigrants settle, and it becomes, a very anti-slavery area. Northern Illinois does, so much like Michigan and Wisconsin. So I hope that answers the question.
I feel like it does, and I do think it goes to population. Like, where are the people who are settling these states from? And I think that helps understand, because I know, Sam, like you guys talked about it tonight, about the upland Southerners coming in and settling Illinois, and, the French already having slavery here, which is why, this is why I think Illinois has such an interesting yet complicated history on this issue, because there is not one clear-cut answer. It's technically slavery was illegal, but yet it was still here. And then there's all these different aspects of slavery. I just find that the topic to be very fascinating, because it's not.
It is fascinating, Heather. And one of the things that I'll emphasize it one more time tonight, Illinoisans face a tremendous problem, in terms of inheriting slavery. How do we reconcile? How do we rid ourselves of this evil? And Illinoisans are able to do it. They're able to do it gradually. They're able to do it peacefully. And that is very commendable. And some folks, that connection wasn't lost on them. And they wish that could be replicated on the national level. But one of the major tragedies of American history, as we all know, is the American Civil War. We weren't able to come to that peaceful solution.
Well, just one last point about this path in Illinois is, look at where we started too. If you go back to, the early 1820s, there was a movement to make Illinois a slave state, to basically change the Constitution to allow Illinois to have slavery. It ultimately failed, thanks to the efforts of Edward Coles, our second governor. But, that's kind of where we started, is that, you've got all these upland Southerners who are living in Illinois saying, yeah, we'd like to have slaves. And then fast forward several decades later, and Illinois is done with slavery.
And we're the first state to ratify the 13th Amendment. So exactly. I feel like that progression is just very we started off very, and then we're the first state to ratify the 13th Amendment, which is pretty impressive considering our history.
From where we had come from, sure.
Right.
Yeah. Well, I would like to thank both of you. We've gotten through the questions, so thank you both for joining us this evening. I'd like to thank our audience for tuning in this evening, and we hope you have a very good evening. Thank you, guys.
Thanks, Heather.